Hi, everybody, and just to let you know that this is Jan Sarek, and I'm the Wisconsin Facets CEO and one of the partners on the Wisconsin Special Ed Mediation System. And with me today I have Nissan Barlev, who is the Director of Special Ed for CESA 7, and we'll give you a little bit more information about us as we go along. We want to welcome you to our presentation today on dispute resolution options that are available to parents and schools. We know that issues, conflicts, disputes, whatever you want to call them, sometimes arise related to planning or implementing IEPs for children with disabilities. The Wisconsin Special Ed Mediation System, and as you can see on the first slide, we've got it abbreviated as WSEMS. So sometimes we use the full name, sometimes the abbreviated name, just so you know what we're talking about. We've been helping parents of children with disabilities in schools resolve issues actually since 1996, when our system first came into being. So during this presentation, we're going to provide you with information about WSEMS and the various options for early dispute resolution that are available through our system. We're going to provide information briefly about how to access these options, and just know that we have a special training that will be available throughout the year or through the year on each one of the options separately. But today is an overview of all of them. And then also we're going to just give you some information about the results of our system over the past 20 years. Okay, let's see. Getting it once. Okay, so the Wisconsin Special Ed Mediation System has been funded by our Wisconsin Department of Public Instruction through an IDEA discretionary grant since 1996 that goes to CESA 7. And for all of these years, the charge of our grant has been to administer the mediation system statewide, to provide a neutral mediation center, to provide training and outreach about the system, and to collect annual and longitudinal data for ongoing evaluation of our system. And WSEMS is really unique nationally in that the system was designed initially way back in 95 and 96 by a 17-member group of stakeholders, and half of the stakeholders represented parent groups and half represented school groups. And that stakeholder council still exists today and continues to serve as a collective, kind of advisory body for the system. So we keep them updated on our statistics, anything we want to change with the system. We really run it past the stakeholders so that it continues to be very stakeholder driven. Our system is also unique nationally because it's led by a team that models partnership and provides oversight to the system. And the partner team, as you can see on the slide, is Nissan Barlev, who's a special ed director for 38 school districts in CESA 7, Northeast Wisconsin, a parent, so I'm the parent of a son with autism, and Wisconsin's Parent Training and Information Center co-director, and then also a dispute resolution professional. Nina Meyerding is an internationally recognized technical expert in mediation, and she's a mediator. She's probably done over 4,000 mediations, and she's a lawyer and a university professor, and she does training really internationally. So, we're really fortunate to have her on our team. But the three of us represent, kind of all of the important players that would participate in mediation or these other forms of dispute resolution. So it gives a really good neutral perspective, well, balanced perspective, I should say, for everything that the system does. So, even our materials and trainings, everything has that lens of a parent and a special ed director and a mediator to make sure that everything, doesn't favor schools or parents, that it's very balanced. And then staff for our system is Jane Burns, who's from Burns Mediation System, and she's the system administrator and intake coordinator. So when you call WSEMS, she's the person that you talk to about your issues and cases. And then Nelsinia Robleski is a parent and also a member of our Wisconsin Facets administrative team, and she's the multicultural outreach coordinator for the system. So one of the attachments that you have is our WSEMS brochure. We also have like a bazillion of these brochures at our mediation office. at the Burns Mediation Center, and also Facets carries a lot, and Nissan has a lot of these. So if you need more brochures and want to hand them out to other people that you know, or you want a hard copy yourself, just be sure and let us know. So this slide is actually one of the first pages in that dispute resolution brochure, and it just shows all of the various ways that parents and schools can resolve their disputes related to special ed in Wisconsin. And obviously, dispute resolution is most effective when it's used at the earliest stage possible. So if you look at the light green arrows, the 4 options in light green, with those options, parents and schools are still able to have some control over the outcome of the issue. Another word for this is self-determination, when you still have control over what happens at the end. That, kind of rather than leaving control of the outcome to somebody else. Parents and schools can work together with the help of a WSEMS neutral mediator or facilitator to reach an agreement that everybody can live with the exception of the first arrow, which is the informal meeting. The other options are the ones that are available through the WSEMS system. So IEP facilitation, the second arrow, mediation, third arrow, and then the resolution process, the other one on the right side. And the options on the dark green arrows, they're available in Wisconsin, but not through WSEMS. So as you move, like on this diagram from left to right, the options really become more coercive, meaning that they're more based on power, who has the most power, who has the most money, threats, so people that have a lot of power usually end up really good with these dark green options. And parents and schools with those dark green ones have really less or little or no opportunity for any self-determination or participation in the outcome. They really give up control of the outcome to somebody else. So like for idea complaints, the Wisconsin DPI staff, Department of Public Instruction staff decide on the outcome. With the due process hearing, which is the second dark green arrow, and the administrative law judge decides the outcome. And with litigation, the arrow on the far right, either a judge or a jury makes a decision. So we're going to discuss the 3 light green arrows today that are available through WSEMS in more detail so that you can understand what they are, how they work, and when's a good time to use one. I will say that what's common amongst all 3 options is all of them start with case intake at the neutral site of Burns Mediation Services, so that's where you call. All of the options are voluntary, which means if one or the other party doesn't want to participate, it doesn't go forward. All of them are free, and all of them use a trained neutral third party from our roster. So Nissan, I'll let you take over, if you're there. Hello, Nissan. Okay. Huh. And I don't know why it can't be heard. So I guess I will. Yeah, can you? Okay, go ahead.
Okay, all right, because we lost you for a while. Could not hear you. But anyway, good morning, folks. I'm Nissan Barlev. And we are down to the slide that talks about cadre. You have the booklet right on the slide. As Jen mentioned earlier, the Wisconsin Dispute Resolution System is a unique system and has been nationally recognized. As part of the U.S. Department of Education project, the Center for Appropriate Dispute Resolution in Special Education, CADRE, reviewed the dispute resolution system of the 50 states and identified 4 state systems as exemplary. Wisconsin was one of them. And if you go to the CADRE website, and we will have a reference to it when we talk about our outreach and our website, but when you go to the cadre, we'll give you the link to that, and you could find this particular booklet about the Wisconsin being an exemplary dispute resolution system in special education. The information was intended essentially for other states to look for ways to improve their dispute resolution system. And we provided a ton of information in terms of our system, our stakeholder process, our forms, and our means of engaging with our mediators. Wisconsin's system was selected primarily because of the high level of stakeholder engagement in the planning, design, and ongoing management of the system. Just like Jan described earlier, we had stakeholders' involvement at every facet of our system. Stakeholder meaning that parents and educators, parents and school folks were involved in every stage of designing and implementing our system. Wisconsin was one of the first pioneer states to provide IP facilitation, which is another option of resolving dispute at the early stage between parents and school, and we'll see in more detail in a few minutes. And we also have a very sound system of measuring quality control of our mediation or IP facilitation. We conduct surveys of all participants at every IP facilitation and mediation, and we review the data to make sure that the services we provide are at the highest possible quality. And this is the time we like to point out that Cadre has a great deal of information about the 4 states, but in general about a lot of mediation IP facilitation. So if this is a topic that interests you, we certainly encourage you to go to the Cadre website, and you will see a lot of information in any kind of modality, any kind of multimedia, in multiple languages, anything that has to do with the mediation, IP facilitation, resolution process in special education. So we're going to be moving to the next, thank you. So this is a visual of how our system works. When a request is received for any of the 3 options, mediation, IP facilitation, or resolution meeting, it goes directly to Jane Burns, which is the WSEMS intake coordinator. Jane is considered to be neutral because she has no affiliation with any parent organization or school group, and nor is she a parent of a child with disability, and she never worked for a school. Jane conducts a very, as you can see from that visual, she conducts a very thorough, impartial process that we call it impartial intake process, that includes screening, education, and analysis. The screening basically consists of intake questions such as finding out the child's name, age, school, grade, disability, whether the child lives at home or a group home, if he receives any therapeutic services, contact information with the school, specific conflict, issue involved, and so on. In terms of education, Jane spends a lot of time educating the 2 parties, both parents and school, about options available through WSEMS. She explained the mediation, the IP facilitation, the resolution process. The analysis part is basically, Jane uses this information that she gathers so she can determine if the case fits the WSEMS criteria and its legal requirement for whether mediation, IP facilitation, or a resolution process. And then, based on this analysis, she provides feedback then to the parties, and then it is the party's choice that whether the school or the parents, or hopefully both, select one of the options that are available through WSEMS. Since the inception of WSCMS back in 1998, through this past summer, we have received almost 1,400 requests for mediation, almost 1,000 requests. Of those, about 1,000 requests actually went to the table to mediation, and almost 90% resulted in a written agreement, which is extremely high success rate for a mediation system. So now we're going to be zeroing in on IEP facilitation. Oh, not yet. We're going to go to the roster. Thank you. So Wisconsin is required by federal law, state law too, to maintain a list of mediators, rosters of what we call the WSMS roster. And we have 25 neutral, 25 mediators, facilitators that we use for all three processes. A key component in any successful mediation system is the perceived impartiality or neutrality of its mediator. And it really comes from the selection process. The selection process, how we selected this mediator, is through an interview process that included a parent representative, that was Jan, a school representative, and I was involved in that, as well as Nina Meyerving and Jane Burns, representing the mediation expertise perspective. So the three of us interviewed every mediator on our system. And if I sensed that there was some questionable neutrality regarding the school perspective, or if Jan sensed there was some questions about the neutrality from the parent perspective, we basically eliminated that mediator. So folks who were left in our on the roster were those that both parents and school perspective indicated neutrality and impartiality. And that was so critical, and we believe that that kind of stakeholder input into the selection process resulted in the roster that folks around Wisconsin have trust and buy into and participation, and resulting then in the high agreement rate that we have seen in our system. But folks sometimes retire, sometimes leave the system, so we have added mediator 3 times since 1995. And again, we use the same system, the same selection process, making sure that folks are perceived neutral by both the school and the parent. That is really critical for us. And we have added then additional folks with different backgrounds, ethnicity, mediation style, geography, location, educational background, life experiences. So we have a fairly diverse group of mediator facilitators. Wisconsin statute also requires that we have a one-day annual training to remain active on the roster. I probably should have mentioned that in the initial process of selecting individual, the initial stage requires 5 days of training in the special ed mediation. And once folks are on the roster, they have to go through annual training to remain active on the roster. And we usually conduct that annual training in the spring. And we also use a stakeholder process to provide them with updating information, but always given the parent perspective and the school perspective. So we have panels of educators and parents providing the mediator with feedback on different issues that come up in Wisconsin. I know we have a section about activities, but we will probably not do that in the interest of time. And I would just mention that one of the typical questions that come up is there advantage or disadvantage of having a lawyer or non-lawyer as a mediator? And the answer is really no. judgment of our intake coordinator if she thinks that it would be worthwhile to have a lawyer mediator when the parties involve lawyers. However, we have seen an agreement rate in our cases that is the same whether the mediator was a lawyer or the mediator was a non-lawyer. Same agreement rate, same high agreement rate. Another item that we are always asked, is it worthwhile to bring an attorney to the mediation process? And again, we look at our data, and 1/3 of our cases involves the parties bringing in attorneys, and 2/3 they do not bring attorneys. And the agreement rate is as high in one as the other. So it really does not make a difference whether there is an attorney present as far as the agreement rate. So, IP facilitation. The IP facilitation, as you saw in the previous diagram that Jan mentioned, is one of the earliest options for conflict prevention that's available through us, meaning parents and school staff still have the ability to resolve their issues and maintain control over the outcome at this point. Even though there are no requirements in IDA 2004, our Wisconsin DPI thought that IP facilitation would be a sound investment in a dispute resolution that could be used even earlier than mediation. So we saw the advice from our stakeholders council, and they helped us develop the guidelines for the IP facilitation process. They made a recommendation about when they thought it should be appropriate to request IP facilitation, who can request the IP facilitation, what intake process would be involved, and agreed on what evaluation information was needed to evaluate and maintain quality control over the system. So it has been available and funded by DPI through WSCMS since 2004. So IP facilitation have been found to increase the likelihood of a successful IP meeting, prevent disputes from developing, resolve disputes early, save time, money, and emotion. The WSCMS roster neutral, the facilitator, attend the IP meeting to help the IP team by facilitating the IP process. This provides a comfortable, productive environment where parents and schools can work together under the guidance of a professional neutral. IP facilitation is free for parents and schools in Wisconsin. And several years ago, our stakeholder council agreed that we should not hold an IP meeting, an IP facilitation longer than 3 hours. If it takes longer, maybe we should be looking at mediation as an option instead. So when to request? Based on our experience, is best if it's done early in the process. And typically when parents or school districts think that IP meeting is going to be difficult to manage because there seems to be lack of trust or communication. So that sense would bring about an IP facilitation. Or when IP meetings have been difficult in the past. Again, difficult because of lack of trust or poor communication between the two parties. The recommendation from our stakeholder council is that IP facilitation could be available for any IP meeting, whether it's initial IP reevaluation, annual IP, or review revision. In other words, any time that we make a change in the student, in the child's program, this may result in some kind of disagreements and therefore the option of going to IP facilitation. So you can see on the screen the request for IP facilitation. So if you think it might be useful to have a facilitator help with an IP meeting, you can start the process by contacting Jane Burns at WSCMS, and you can see the phone number on the slide. The request for IP facilitation form is available online, and it is on the website is, as you can see from that, is wscms.us. That's the easiest way to reach the website. Either the parents or school or both then can complete the form to make a request. If just one party signed the form, then Jane contact the other party to ask for consent to the IP facilitation and talk about the benefits of facilitation and how the process works. The IP facilitation is voluntary, so if either party doesn't want to use it, then it doesn't move forward. Jane then does the case intake and screening, as we mentioned earlier, so I will not repeat that. And you can find the screening form on our mediation manual as an Appendix D in the booklet. If the parties want to, they can look over the list of roster neutral and pick one that they agree on. Otherwise, Jane then looks over the case circumstances and matches with the facilitator. And then once a case is assigned, then it moves very, very quickly because IP, as you know, is time sensitive. It has to be done in a certain time frame. So we move on to the next page, next slide. And the participants. Because IP facilitation are not required as a dispute resolution option in either IDA or state law, there are really no legal provision about who may or may not participate other than what's already defined in IDA as participants of an IPT meeting. So the only exception is that you have a facilitator. The facilitator then is not a member of the IP team. And what is meant by that is that they do not address the content of the discussion, but instead they help out with the process, with the discussion itself. And you can see from this slide. Okay, you can go back to the other one, Jan.
One?
Yeah, no, forward. One more.
Sorry, that one.
Yeah, okay, the role. So we are at the role of the facilitator. So there are things the facilitator will be focusing in doing the IEP meeting. And again, the discussion is not about content. Content is only the parents and the school staff. The role of the facilitator, as we can see, is helping the parties focus on joint problem solving and mutual goals rather than spending time blaming or attacking each other. Helping the parties focus on the best interests of the child, helping clarify points of agreement, disagreement, reframing points of disagreement into manageable things to discuss. Modeling and encouraging active listening skill by establishing good eye contact when culturally appropriate. Showing empathy to both parties in a balanced way and expressing understanding of each party's different perspective. Reframing judgment words so that no one loses face. So you can see why he is the facilitator. He or she is not part of an IP team discussion on classroom management, but more of a process management and making sure that the discussion flows smoothly and constructively, resulting in a constructive IEP. So, and we move on to the next slide, is that in order to avoid confusion by IEP participants as to the role of the facilitator, we provided our facilitator with suggested opening for them to use at the start of the meeting when they introduce themselves. And that is really important. And it basically says, I am not a former member of the IP team. I will be working with a case manager. So before the IP meeting begins, the facilitator then asks all the IP team participants to sign, and the facilitator also signs the WSEMS agreement to use the WSEMS facilitated IP process. The agreement outlined that everyone agrees to use the process, everyone agrees on the facilitator, everyone understands the role of the facilitator, including that they cannot provide legal advice or advocacy for the participants. They understand, the parties understand that they can go on to use mediation instead if they want to. And it confirms that the party understands the process does not have any of the confidentiality protection that's in mediation, but does provide the confidentiality protection afforded at the IP meeting and IP documentation by IDA 2004 and Wisconsin Chapter 115. And then the next slide.
I was just going to say one of the handouts that's available to them through this program is the agreement to facilitate, so they can actually. Great.
So it should be there. So this will be the last slide of IP facilitation. And basically, as we mentioned earlier, we maintain quality control. We ask every participant at every IP facilitation to give us their opinion on multiple items. And based on, and we use that, and it's done confidentially. There are no names attached, and it allows our intake person and Nina Meyerding to review it and to make appropriate recommendations. So the outcome of the survey, as you can see from the slide, that almost 90% were satisfied with the process. 77 felt that facilitation gave them an opportunity to be part of the IP process. 76% thought IP facilitation will improve future IPs. 86% will use the same facilitator, and so on. And you can read the rest. Give us some additional information about who are the folks who use the IP facilitation. Go ahead, Jane. Yeah.
So we're going to talk now about mediation. So if you remember with those diagrams with the arrows, mediation was the next one after the facilitated IEP option. It doesn't mean that you have to use one before the other. You can really jump in either place. In mediation, a trained neutral person, in this case that we call a mediator from the WSEMS roster of neutrals, facilitates the discussion and helps parties, schools and parents, reach their own agreement together. And we provided you as one of the handouts that you can get, that you can download here, the 2014 WSEMS Mediation Manual, which is, it's quite a long manual. If you want a hard copy, just let us know. We can mail it out to you. But at least you have it available to you electronically if you want. But this is useful to use yourself or to share with parents or school staff when they're thinking about using the mediation process or when they're actually preparing for mediation. It's really a cool manual. It's divided into 3 sections, an overview of the process, and then there's a section for parents, one for schools and one for attorney advocates. And essentially, when you look at them all the sections are pretty much the same, with very few exceptions, but which means that parents and schools really prepare for mediation pretty much in the same way. Since IDEA 1997, mediation is a dispute resolution option that's been required by federal and state law to be available to schools and parents. So up at the top, you see the laws that are most important to our mediation system. So federally, IDEA 2004, Section 615 and the regulations, those are both, you can read both of them in the mediation manual in Appendix A and B. And sometime when you have a chance, I think it's really important to take a look at what that actually says. The federal is short. Wisconsin statutes are available to you in that manual also in Appendix C, and that's Chapter 115, 797. And those are the statutes that our stakeholders actually wrote together. So it's really been that was a very transparent, open process for setting up our system. And then 802.12, which is listed there, is a statute that applies to all forms of mediation in Wisconsin, and pretty much what you're going to find there is the definition of what mediation is in Wisconsin. And then the last one, 904.085, relates to the admissibility of information from any mediation in Wisconsin into legal proceedings. And what's important about this one, and you'll read it if you read the manual, is that this includes confidentiality protections for mediators. So mediators cannot be called to testify about what happened in mediation, you know, in further processes. And this is important. And, you know, talks about parties, you know, not sharing that information that a party, I mean, they can't share information about what happened in mediation, or they can't also share information that somebody declined to participate, which, you know, could be important information for in a due process hearing or something, and you don't want that to come out either. So that confidentiality is really important, so that parties can really openly discuss issues in mediation in a safe, confidential environment. And that's the difference, big difference between facilitated IEPs and mediation, is that huge confidentiality piece. The Stakeholder Council also decided that the names of parents and school districts would not be shared really at all. So the only thing that the WSEMS system shares with DPI or anybody else publicly is the number of requests for mediation that we got, the number that one or the other party declined, and the number of agreements that were reached with parties that were reached. And I think that's important, because it's a chilling effect if, for example, schools know that DPI is going to know that they have a mediation going on. They might not want to go to mediation because they're going to think it maybe doesn't reflect well. So, and the same thing with parents. They may not want anybody to know that they've gone to mediation. So it's really important that, you know, we've protected that pretty carefully, that we do not share that. And even Nissan and I do not know who calls the case unless it's somebody that's, you know, from our own staff. The only people that really know who the cases are Jane Burns and Nina Meyerding. Discussions in mediation have to remain confidential within the limits of law that we mentioned, and also for our state law. We don't keep records, and that means that, you know, while you're in a mediation, you could take notes, but they really have to be destroyed after the, you know, as you leave the mediation. And the notes aren't shared by the mediator or anything else. So if a mediation agreement is reached, only the parents and the school get a copy of it, not the mediator, not WSEMS, and not DPI. So that agreement remains with the parties that participated in mediation. And again, just to you know, re-mention that this process is free to participate in. So when is it the best time to request mediation? I would say obviously early in the process, when help is needed to settle a specific dispute. When a facilitated IEP is good when issues are still swirling around. This is when, you know, you've got a specific dispute, when you've kind of impasse has been reached, or we, as we say, when, you know, kind of the discussion has hit a brick wall and there's no movement forward, or when you have a really strong history of dispute between parents and schools. Definitely a referral for special education must have been made. So we can't use this system for general ed students or for issues related to 504 plans. And so any request, the student has to be in the special ed pipeline somewhere, as early as a referral, but anywhere else. Federal and state law provides that mediation can be used for, and you can see issues dealing with those things listed there. I would say that the provision of FAPE means that it's applied pretty broadly. So pretty much almost anybody that's already in the system of special ed really could use the system. Other reasons for considering mediation, if you need, and you can see that again, need for privacy and confidentiality, need for creative and flexible solutions, and need to be forward-looking. I think the most significant impact of mediation is the chance to establish a better or a good collaborative partnership that not only helps in resolving the present, you know, dispute, but also starts parents and schools on the path with a framework to resolve future disputes with sort of good communication. Here's the request for what it looks like for mediation. And again, this is in your mediation manual that's in one of the handouts. The request for mediation has to be in writing, and it has to be sent to the WSDM office. So the mediation, it's in the mediation manual. It's also available on the WSDMS website. You can see that there's a really tiny little space in there in the middle of that form to briefly describe what the dispute is. And kind of the reason for that is, you know, you can, once you get into mediation, you can talk about a lot of things that may relate to that issue. And people are used to writing a due process hearing request, which might be 50 pages long and very detailed. This, you just could write, say, transportation issues in the square, or IEP issues, or placement issues. Don't have to be, you know, that exact with what you write in that space. We encourage joint requests, so we really encourage people to try to have both parents and schools sign the form, but the process can start with just one signature. A single request takes longer to get the process rolling because Jane Burns has to follow up with the other party to get a second signature. There's really short timelines included in state law for notifying the other party and for that party to respond. The letters that get sent out are in the mediation manual. You can see them in Appendix E if you want to know what they look like. So our neutral intake center is really critical to the success of this system, and nobody, again, outside of Jane Burns, knows which parents and schools request mediation. She screens the request again, just like Nissan talked about in the facilitated IEP process, to make sure that the case meets the legal requirements to be able to take the case. And then uses the same screening questions as for facilitated IEP. Again, you can see that in Appendix D. What is great about mediation is that every step of the process is voluntary. So you only have to participate if you want to. You can stop anytime if you want to, even if you're in the middle of the actual mediation session. You can say, this isn't working for me, I'm done. If a parent requests mediation, the school doesn't have to agree to go to mediation, and vice versa. Scheduling is a really fast process versus like with IDEA complaints, they have to be scheduled within 60 days. With due process hearings, it's 45 days. With mediation, it has to be scheduled within 21 days after the mediator is appointed. So the sooner the parties agree on a mediator, the faster the mediation can move forward. And I would say either the parents or the school can suggest a mediator. If they can't agree on one, Jane suggests one. She usually will suggest 3 and then have everybody strike 2, and she ends up with, you know, there's one that will be a common one. The mediator who works with the parents and the schools to schedule the mediation session for a date and location convenient to both, that's who actually works to get it scheduled. So it's not Jane that schedules it. It's once the mediator is appointed, it's the mediator that sets up the mediation. But just know that it can be in environments other than the school, possibly. It could be at the public library or a community center or a bank. A lot of them are done at the school. Some are done in attorney offices. The mediation does not have a time limit like facilitated IEPs did. Usually they take part of a day. The average is about 4.5 hours. Some take longer, some take several sessions, and some, several days. But parties in general are asked to agree to a general schedule and, set aside some days so it's on your calendar before the session starts. Who participates in mediation? By law, law provides that mediation participants include 2 parents and 2 LEA or local education agency representatives. And the parents, if the child is over 18 and a competent adult student, that would be that student, and then the parents could participate if the student, signed a paper that said it was okay. The school reps, since the school reps weren't defined further in our Wisconsin law, one of those could possibly be a school attorney. And then other people can participate, but the parties, the parents in the schools have to agree on who those additional people were. So any other people that parents would like to have attend, like relatives or neighbors or advocates or attorneys, must be approved by the school. And anybody that the school feels would be useful, like other IEP team members, that has to be approved by the parents. And then Nissan already mentioned attorneys, and you know, we've really said oftentimes better to have them in the room so they can hear the discussion. Otherwise, you know, if somebody has an attorney, they're going to consult them after the meeting, or, you know, stop the meeting and then just, you know, go call them on the phone, and they won't have heard any of the proceedings. So, you know, it's really better to have them in the room so that they've heard the whole discussion, if there is going to be one there. And they might also be helpful for providing legal information as well. So that's who can participate. And then briefly about the mediator's role. The mediator helps the parties decide who's going to participate in mediation, as I said, spends time to make sure that everybody understands what to expect from mediation. So that may be in a call in advance of mediation, or it might be right at the beginning of a mediation session. And they really talk about the fact that their role is to help facilitate and structure the discussion that happens, or is going to happen, between the parties during the mediation session. You know, as I said, as I think Nissan said before, the WSEMS trains the mediators so that they have a working knowledge of special ed laws. They know the terminology that we use in special education. They learn about current issues like open enrollment or vouchers or Common Core essential elements assessments. They, you know, or any new laws that have passed, like seclusion restraint, or when we passed the new specific learning disabilities eligibility requirements. So they learn those things, but their role, because their role isn't to impose a decision or to interpret law during mediation, you know, they don't have necessarily that in-depth knowledge of the law. Their goal is to help parties really converse and reach an agreement about their issues. The mediation process is informal. Everybody is usually in the same room. Sometimes the parties meet separately, and you guys have heard the word caucus, and meaning, or shuttle mediation, where the mediator goes between rooms to talk to parties separately, and that sometimes does happen in our mediations. A couple of processes that happen in a mediation session when it starts. Usually there's an opening where the mediator explains the agreement to mediate, which you can find in Appendix G in that mediation manual, and that really includes that everybody has agreed to use that certain mediator that's been named or that is there. Everybody understands that he or she can't give legal advice. They all understand the confidentiality provision, and that parties really need to keep the process and contents of the process confidential from others, and explains about the no audio, video, or written record of the session. Everybody present signs the agreement to mediate. So that's the parent, the school, if there's any other parties, plus the mediator. So everybody signs that. And then during the session, the mediator explains the mediation process, their role, and then starts by asking participants to explain why they're there and what they would like to see as a positive outcome of the, the dispute. They may take time to ask questions, to clarify, to brainstorm, to do some option creating, and then the mediator really explains circumstances that could lead to the termination of mediation, either by reaching agreement, by the mediator stopping the mediation, saying that they don't think that further efforts there are going to contribute to the resolution of the dispute, or if either the parent or the school says, this isn't working for me, I want to quit, finish this. So, yes, let's see. Okay, so the mediation agreement, if there is one, must be written. So in the manual on page 11 and 35, you can see that there isn't a specific format or template for the agreement. Parties really just write down like in bullet points, what they feel like they're going to be able to do to resolve the situation. We really highly advise that agreement to be super specific so that it's very clear to everybody who's going to do what, by when, And then if there's any pending processes, like if there's a dispute resolution or a due process hearing that's been requested, or an IDEA complaint or an OCR complaint, it's really important as part of the agreement to agree to withdraw from that process, because theoretically now you've resolved the issue, so that those processes don't have to go forward anymore. And then to include a statement in the agreement is our recommendation that you agree to loop back to mediation if things start falling apart. So if all of a sudden you find out that deadlines aren't being met or something like that, you know, that you would all agree to go back to mediation. And then there's certain language that has to be in the agreement that's federally required, and you can see that right on the slide. The mediator can be a scrivener and write down what the parties say, so it's either the party can write the agreement or the mediator could write it for what the parties say. And once the agreement is written, just the parties sign it. So it would be the parents and the school person that signs the agreement. Either party could have an attorney review the agreement. And then again, as I mentioned before, only the two parties get a copy of the agreement, not WSEMS and not DPI. So some mediators keep a copy, but most of them don't, because they don't want to have to be responsible for any of the contents. In Wisconsin, the agreement is legally binding under Wisconsin contract law. So WSEMS, we don't have any responsibility for enforcing the agreement, but I would say that people tend to follow the terms of mediated agreements because they participated in developing them. So, you know, as you can see, by kind of the statistics that we gave at the beginning, nothing guarantees that going to mediation is going to lead to agreement, but we really have a high rate of agreement for our system. And even if you don't get an agreement, just the process of trying this out often, you know, it often helps parties to identify what the issues are, because sometimes it's swirling around so much they don't even exactly know. Or sometimes a partial agreement can be reached on some of the issues, or it may just help in, you know, better discussion in the future. Okay, so again, satisfaction with mediation. You can see that all of the numbers for over the 15 years that we've been doing this, or that we have records of, are really high. They're, you know, nearly 90% or over 90% for all of them. And again, the survey that is taken is anonymous, so it's given anonymously and remains confidential for individual people's responses. But this really helps us show to our stakeholder council that the mediation process is working. Okay, and then there's a sample of the survey in the mediation manual. Okay, Nissan.
All right, thank you, Jan. We're not going to be spending a lot of time on this option resolution process, the newest option available, and it kicks in usually when parents file a due process hearing. The IDA 2004 now allows local school districts 30 days to resolve the complaint to the satisfaction of the parents. And if it's not resolved in 30 days, then the due process proceedings takes place. So it's the only option would be for district and parents if they agree that they both do not want to participate in the resolution process. They can either opt out of that and go directly to mediation, or go directly to a due process hearing. So it's just an option available for parents in school if they want to attempt one more time a non-litigious option, that is the opportunity for school and parent to meet within 30 days and resolve it before attorneys take over and it becomes very litigious process. So that's all we're going to say about that. And what you have on your slide is the form that parents and school can jointly waive this process. But if one party wants to do it, the other one doesn't, then it cannot be. Then it has to be both parties agree to waive it. So let's move on to the next slide, which is the outreach. And I mentioned earlier that the outreach is that at this point we're going to talk a little bit about cadre. And this is our website, and it's very simple, wsems.us. And you'll be able to access the various categories that we have. Typically in outreach, Jan and I do a lot of the presentation. Again, a parent and an educator side by side carries a great weight when folks are able to see both perspectives at the same time and listen to the two parties. Narcinia also assists with the cross-cultural presentation. She also translated all of our website into Spanish, so it's available. It parallels pretty much all of our items in English, also in Spanish. So what we do in terms of outreach, we provide training to parents, school professionals, and others statewide, either through phone conferences, webinar like this one, or opportunities in person as well. We have archived many of our presentations so folks could access them 24/7. And the training is in both English and Spanish. We also have a resource site where you can click on it and it'll take you to Cadre and several other sites. We're very impressed with Cadre's selection of material. I would encourage anyone that has interest in this area to explore the Cadre material. We don't have time for the two final slides, which have videos in them. But again, you will be able to see those videos on the Cadre website. So you go to Cadre and ask for and search for the videos, and you'll be able to access both of these videos. Go ahead, Jen.
So we just had one question come in, and it's can the mediation, if no agreement is reached, does a copy go to the due process hearing? And the answer is no. And the reason why is because of that confidentiality provision is that, you know, even if an agreement would be reached, you still can't introduce that agreement anywhere else. In fact, one of the things that in the mediation agreements, that if you get one, that you normally would discuss how the agreement points are going to be disseminated to other people. So, for example, if something has to go through, you know, how is it going to be introduced to the IEP team? Because you can't bring the agreement itself to the IEP, but everybody, you know, but the people that participated knows what the agreement was. The same thing as the school can't put the mediation agreement in the regular student file. They have to put it in their administrative files because it can't follow the student to another school district. It has to stay back with that school because it was the school that was, you know, part of that mediation. So it's confidential, cannot be introduced anywhere else. You know, and the mediator can't say that we didn't have an agreement. The parents in the school can't say we didn't have an agreement. So it goes nowhere.
Yeah, and that's absolutely correct. This, what I see, is one of the strengths of the mediation process. In fact, Congress intended it from the very beginning to provide a free area where people can explore different options, can look at different solutions without feeling that whatever is being said there is going to follow up in future litigious proceedings. So whatever is discussed in mediation, whether there's an agreement or not, that stays private. And then, as Jen mentioned, if let's say that the conversation and the outcome of the mediation is that the kid will receive speech and language 3 times a week, the only thing that goes to an IEP meeting is the speech and language 3 times a week, period. Nothing beyond that. Everything else, all discussions, all conversation, exchanges remain confidential.
So I'm looking to see if there's any other questions. I just wanted to make sure that I got them. I think that's the only one that we have, just to make sure. Okay, so that we answered them. So I think we're good. So this really concludes our webinar for today. We really want to thank you so much for joining us. We have, as I said, at least one, for most months, we have at least one training offered from WSCMS on our various dispute resolution options. We also have our new productive and friendly IEP training that's coming up as well. So if you want to check the website calendar on either the WSCMS website or the Wisconsin Facets website and register for upcoming trainings, please do so. And then again, please watch for our short evaluation that will be coming to you in a couple of hours. And we hope you guys have a good rest of the day. Thanks so much for being with us today.